generally prohibited from doing so, as long as there is a recognized jurisdictional basis and an overall reasonable test is met. And that's what we have in the Canadian legislation. What about the OAS? The court has recognized the state's obligation to prevent human rights violations by third party. There's no reference today to the use of extraterritorial regulation to prevent overseas abuse by a corporation based in the state party. The court also stated concerning indigenous communities that it is mandatory to consult indigenous peoples before authorizing the exploration and exploitation of natural resources. But there's less consistent on, they're less consistent on whether the consent of such people must be obtained. So obviously further guidance from the OAS is definitely recommended. Besides the work of Professor John Ruggie, which is the Special Rapporteur's framework I just talked to you about, there are other UN agencies that are concerned with this matter. The Committee on Economic and Social Cultural Rights and the Committee on the Elimination of Racial Discrimination have directly encouraged states, specifically Canada and the United States, to take steps to prevent abuse abroad by corporations within their jurisdiction and to hold them accountable. I want to attract your attention to the UN, the Committee on the Elimination of Racial Discrimination and recommendation to Canada. The committee encourages Canada to take appropriate legislative or administrative measures to prevent acts of transnational corporations registered in Canada which negatively impact on the enjoyment of rights of Indigenous peoples in territories outside Canada. So that's very, very clear. In particular, the committee recommends that Canada explores ways to hold transnational corporations registered in Canada accountable. So this committee, of course, does not make the law universal, but that's a very good start. The same recommendation was made for the United States concerning Indigenous peoples' rights. So I just want to outline three particular areas that would benefit from greater clarity from the UN. Is one, whether states should impose liability on companies themselves, in addition to the natural persons acting on the entity's behalf. The second one is when states are expected to provide individuals with civil causes of actions against companies. And the third is to what extent states should hold companies liable for alleged abuses occurring overseas. So as it stands at the international level, there are still much more to be done. Briefly, Canada, do you have time? So how did Canada implement or incorporate, or is not incorporating these international obligations into law? We have a non-judicial mechanism that just been published, I would say. It's a new Canadian strategy called Building the Canadian Advantage, and Catherine will talk about it after my presentation. And if you go, and that's a non-judicial mechanism. Now the judicial mechanism, if we look at the criminal, we have a law, Crimes Against Humanity and War Crimes Act. And for the civil, we have the two civil regimes which are different from common law, provinces of common law, which would be the torts. And for Quebec, it's extra-patrimonial regime which would apply. There is no Canadian equivalent to the U.S. Alien Tort Claims Act, which empowers foreign plaintiffs to sue domestic corporations for actions committed offshore. Let's go back to the Crimes Against Humanity and War Crimes Act. enables a company heads and the entity, company itself, to liability for genocide, war crimes, and crimes against humanities. Of course, these crimes are extremes and they're quite isolated, although the companies have been accused of it. The main thing to remember about this act is that in these very serious crimes and exceptionally, Solicitor General consent to sue is mandatory. So far, since it's been adopted in 2000, there's no lawsuits that have been authorized by the Canadian government. Civil, there's been 3 lawsuits in Canada, 2 lawsuits in Quebec, and 1 lawsuit in Ontario. Cambia is a Quebec firm operating in Vienna and was sued for environmental damages in 1995. Green Park are construction companies, Quebec companies operating in West Bank in the Palestinian territory occupied by Israel, accused of complicity of war crimes. And the third one is Coumans Mining and the Toronto Stock Exchange. First, Coumans is operating in Ecuador and being financed by the stock exchange. And the allegation is complicity in human rights abuses for the company and a stock exchange for giving access to the financial means. These 2 decisions, there's 2 decisions on 3 lawsuits. 2 of them have been refused to be heard in Quebec. Is the Cambia and Green Park has just been decided a few weeks ago. The main legal obstacle, because we don't have a law, is the judge has to choose the competent tribunal to hear a case, and they will have a discretionary power over that decision. Some criteria and conditions have been elaborated within many legal decisions. So they base their decisions on different criteria to find out that in these 2 cases, Quebec was not the appropriate tribunal to hear the case, but it would be in Cambia, it was Guyana, and for the West Bank, it's still Israel. Coumans is still ongoing in the Superior Court of Ontario. Just very quickly, so as you can see, our legal system is not up there to be able to have any incentive or deterrent effect on these human rights allegations. So what's been happening during those years, lawsuits have been occurring abroad in other countries. Taliban has been sued in the US, and Anvil has been sued in the Democratic Republic of Congo and Australia. All these cases have not resolved in giving any a remedy to the victims. What is also happening, as you know, as other governments are reacting to our company's activities. As one example, we can cite the Norwegian government who retracted Barrick Gold from its list of funds, government funds.